Damos inicio al siguiente panel. Por favor, el video de...
We are going to start, please, the video. Copyright versus IA copyright. Megan Carpenter, Dean of the Faculty of Law, Franklin Pierce of the University of New Hampshire. Juan Manuel Díaz, Judicial Boss of CARACOL Television. Moderator, Pamela GISHOLT, Associate Manager of the Technology Area of the Information and Communication of Intellectual Property, AROCHI in Mexico. Good afternoon, everyone. It's a pleasure to be here with you. Due that we have some panelists today from different countries and places, I think that we are going to do this in English. Though someone doesn't agree with that, I think it's a more harmonious way to do it.
Interesting topics that we have been discussing like for the last, I don't know, maybe the last year, because copyrights is something that always call our attention. And copyrights is something complicated, and when we mix with something very new and very disrupting technology, such as artificial intelligence, I think that then we have something to talk about and to discuss like a lot. So in this case, we have two very different panelists. Meg comes from the US. He's on the teaching side. She's a dean at the University of New Hampshire, as we were like hearing just a few minutes ago. And Juan Manuel is in Colombia, in the practice area. He's in CARACOL Televisión. So I think that we can have here a mix of opinions and what is going on, not only in Colombia and the US, but all over the world. So I think that we can start with Meg. For what do you have to say about this topic?
Thank you so much, Pamela. And thanks to ASIPI for having me here and having us here as a partner school. You know, throughout history, every technological advancement that we have seen has really reshaped our understanding of creativity in the copyright space. And what we're going to try to do today is to draw on some of the discussions that have happened this morning, and not to overlap too much, but to dive into individual pieces of it. But from the printing press to the camera to AI, each innovation has really expanded the boundaries of what's possible. And I mean, who knew with the invention of the camera that we would all be taking pictures of our food all the time at restaurants? So as we navigate these changes and as we're in conversations over the course of the next two days, I want to remember something. And this is contrary to what I typically say. Usually when we're talking about new technologies and I'm thinking about legal perspectives and frameworks, I will often say we don't need something new. We don't need to create new legal frameworks for the metaverse or for NFTs. That what we have is really sufficient. But I don't want to get distracted by sort of the hype cycle, and I think that largely the IP framework that we have globally is a solid one. And in some ways that's true here. But in other ways, artificial intelligence really does change the game. And it's challenging some of the fundamental concepts that are inherent to IP. Some of these we were discussing last night at the reception. You know, what is intelligence? This came up in the last panel as well as a reflection. You know, what is authorship? What does it take to be creative? And can an AI tool indeed generate a creative work? So language and framing really matter. And I just want to show you this video and have to frame our discussion. This is Steve Jobs talking in Santa Clara.
The thing I would say is when you grow up, you tend to get told that the world is the way it is, and your life is just to live your life inside the world, try not to bash into the walls too much, try to have a nice family life, have fun, save a little money. But life, that's a very limited life. Life can be much broader once you discover one simple fact, and that is everything around you that you call life was made up by people that were no smarter than you. And you can change it. You can influence it. You can build your own things that other people can use. And the minute that you understand that you can poke life and actually something will, if you push in, something will pop out the other side, that you can change it, you can mold it. That's maybe the most important thing, is to shake off this erroneous notion that life is there and you're just going to live in it, versus embrace it, change it, improve it, make your mark upon it. I think that's very important. And however you learn that, once you learn it, you'll want to change life and make it better, because it's kind of messed up in a lot of ways. Once you learn that, you'll never be the same again.
As AI tools become more sophisticated, they raise critical questions about the kind of life that we want to live together as a society. And as Steve Jobs points out, that life as we know it isn't immutable, and law isn't either. And we design the world, and in some ways, the world then designs us back. Law doesn't just reflect behavior, but it also shapes it. So as we think about how we want to construct this new world, it's not just kind of thinking about what previous case law or statutes have to say to define creativity and to define authorship, but to the extent that it has profound impacts on our behavior and our productivity, our humanity, and incentivizing humans to create. And is that even important to us anymore? So I'm going to focus primarily on the US today, but I want to give a little bit of a global perspective. And focus on just a couple of things coming out from different regions that help us understand about language and framing. The European Union has it was a case from 2009, Infopack versus Dansky. And Infopack was is a media monitoring and analysis business. And in that case, the Court of Justice for the EU held that the company could only have copyright if there's originality that flows from the author's own intellectual creation. And so widely interpreted that the significant involvement of human creation is required. So individual member states will in turn determine what that means country to country, but it needs to kind of fit in with that intellectual creation language. It won't surprise you that, in France, where moral rights, natural rights are very prominent, that they talk about kind of a personal touch with that intellectual creation. Germany requires an author. In the UK, we see intellectual creation also in a personal touch, but there's something really interesting in 1988 from the Copyright Designs and Patents Act, which provides a copyright in the UK for computer-generated works. And that's in section 9.3, which is interesting, and it attributes the copyright to the person who made the arrangements for that, the product that's generated. In China, we have similar language with very sort of different results. The language is intellectual achievement, but there are two cases that are recent that can be instructive. Shenzhen, Tencent from 2019, where there was DreamWriter AI software from Tencent, and the court held that AI software can be copyright, that the intellectual achievement happens through both the inputs and the outputs, through the prompts and condition setting. And then that was really reinforced with the Beijing Internet Court in 2023, where a stable diffusion image was allowed to have copyright and was held to meet the requirements because, again, putting in those prompts, setting the parameters. So in the US, copyright is a little different. I want to ground us in what the fundamentals of US copyright, but then some of the cases that might help inform where we're going to go. First, copyright exists in any work, expressive work, that is a work of authorship fixed in some tangible medium, and that exists right upon creation. Those rights are derived from the US Constitution. Key cases here, I would say, while we say there's a work of authorship fixed in a tangible medium, we all learned in 2018 that is human authorship, guidance from the Copyright Office. It doesn't happen if a monkey accidentally takes a selfie. The Copyright Office quickly came up with guidance that said it must be human authorship. Thaler versus Perlmutter was a case that just was from the end of 2023 into 2024, where Stephen Thaler created this image called Return to Paradise. And it was generated with AI. And in 2019, the Copyright Office said, it rejected copyright for it. But he reapplied more recently and focused on his prompts, the generation work that he contributed to that effort. And the Copyright Office came back and said, this one isn't complicated. There might be complicated questions that come down the line, but this one doesn't cut it. And they referred to this case here, Cerrone, which is about a photograph. It's the first case in the US in the Supreme Court that said that photographs were able to be protected by copyright. And they referred to that saying that really there needs to be a human element to it. I think you could actually use that case on the other side, because Cerrone said, the Supreme Court said that in this case, photographs can be protected by copyright where it's the camera is used as a tool, that it's really the creation of the subject. When you take the photograph, the posing of the subject, how you set that up. And I think that can be certainly relevant as we look more at some of the cases pending in courts today. But very much key to US copyright is this romantic notion. This is William Wordsworth, kind of the development of poetry and expressive works being so closely tied to our soul, kind of who we are as human beings. But here I'm going to talk about a few things that exist in copyright in the US that I think are going to inform some of the pending cases that we're going to see coming forward, whether it's single authors, joint authors, or work for hire. Those exist in compilations and collective works, and then joint works, where a work is prepared by two or more authors with the intention that their contributions are merged into some kind of inseparable or interdependent whole. A compilation is a work that's formed by assembling pre-existing materials or data. A collective work is gathering multiple works together and putting them into one. Okay, so I'm going to tell you about 3 cases that I think are getting ignored, but as we are looking at the litigation that will, as the previous panel noted, is going to play out for years to come, I think look for the relevance in these 3 cases. First is Mannion versus Coors Brewing Company. And in Mannion versus Coors, it's kind of the modern day Cerrone, the modern day Oscar Wilde photograph case. And in that case, the Southern District of New York, which is pretty active in this space, the court talked about copyrightability derived from rendition, or the techniques that you use in creating the work, the timing of it, how you construct the subject. And what they said is that you ask kind of where is the spark of creativity and who is guiding that? AI, anyone? It seems so parallel to some of the tools that we're using through the creation of AI works as well. One more case, the Titanic case. Here, the plaintiff kind of filmed and directed, I'm using air quotes because that's a judgment call, a documentary about the sinking of the Titanic. The plaintiff created storyboards, designed light towers to film underwater, selected the angles for those towers, directed the filming and gave photographers detailed instructions. The defendant's argument was, wait, you might have directed, but you didn't do any of the filming yourself. Again, a very strong application to generative AI here. And the result was that, again, in the Southern District of New York, that where the plaintiff exercised a high degree of control over some kind of film operation where the final product duplicates his efforts, his conceptions and visions, that constitutes authorship. In Al Muhammad, this was about a movie that Spike Lee did about Malcolm X, and there was someone who wanted also co-writing credit. And in that case, the plaintiff had helped direct the individual actors, helped with some of the historical guidance. But in that case, the Ninth Circuit, on the other side of the US in California, said, you know, there's so many people involved in the creation of a film that if each person who helped contribute to that vision got authorship credit, it would just all fall apart, and that the industry just doesn't work that way. So I think this case is kind of instructive in a way because it helps us understand that industry needs, market needs are relevant too. So these three cases, whether it's the Mannion versus Coors, the Titanic, Malcolm X, all of that falls apart as we're seeing what's happening in the way the Copyright Office is right now treating works generated with the use of AI tools. Many of you are probably familiar with Zarya of the Dawn, in which case we learn that the Copyright Office is very unlikely to find requisite human authorship when there's an AI program that's going to generate visual works in response to text prompts. The person who created this comic book or graphic work was Chris Kashtanova, and she used Midjourney, which we just saw a great demonstration of in the last panel. And through her, she registered the copyright in September 2022. A few months later, the Copyright Office reached back out and said, wait a second, it's come to our attention that you used an AI tool in the generation of your comic book, and we want you to tell us, how you used it and how you were particularly involved in that generation. And she responded that it was a creative, iterative process with hundreds or thousands of prompts for every visual image. And like we saw in the last panel, with a fairly simple graphic, it can take more than a dozen attempts to get it, even sort of halfway decent. So here is an example of one final image that she created. And I'm just going to show you how she kind of got there. This is her process. You see one image evolve. She started with this. And the prompt was dark skin hands holding an old photograph at 16:9, which is the kind of proportion of the image that she wanted. So this is what she got. She put in more prompts. She's getting more and more and more. More prompts, getting us eventually to where she kind of ended up. More, where she ended up finally to this particular image. And so you can see that evolve, and here are just a fraction of some of the descriptive prompts that she used, which itself kind of seems like a poetry.
Do you hear me? Yes. And Meg, with all this that we have been seeing, what are your predictions? Like, what could be like going on now and from this point?
Well, I'm glad you asked. So here's my prediction. My prediction is unstable diffusion. It is that this is a fluid situation. I think it's a moving target, and that in the US, that the Copyright Office is going to eventually relax its standards. It's taken some bright lines, and this is not a bright line situation. There's a spectrum of how people can utilize a tool, whether it's, it's the same thing that goes for a camera, the same thing that goes for Photoshop, or filters on your phone. And AI tools are tools as well. And so I think it's going to eventually, we've evolved from the printing press. We've evolved from the Wordsworth, everything I create has to be my soul. And we're coming to a place where humans can work with technology to create something new. And so I would predict that the Copyright Office is going to kind of shift its perspective over time. All right, so what I'd like to talk about now are the input, kind of the use of copyrighted works in training data itself. Again, a brief global perspective. We know that in the EU there is the AI Act that's requiring sort of transparency in copyrighted content, taken a pretty strong regulatory approach. In Japan in 2018, there were revisions to the Copyright Act, and I want to use this really as an example globally. This is not unique to Japan, but the revisions to the Copyright Act there talked about that it is permissible to exploit a work in any way and to the extent necessary if it's done for use in data analysis. And here this reflects again what we were talking about language. Language matters. Is it data analysis or is it copyright infringement? And I think you could make the argument either way. In the US, we're seeing action on multiple fronts. The Copyright Office had a request for comments on training data and generative AI, which closed in December, and we're expecting sometime this summer to hear some results from the Copyright Office. Also, we're seeing stuff from the legislative and the executive branch. So the executive, President Biden issued an executive order asking the Copyright Office for policy guidance, which is expected next month. And then, in the legislative branch, of course, our Congress can't really manage to do anything right now, but they also, there is a bill that was introduced that would provide some kind of regulation of training data itself. It's the kind of AI Foundation Model Transparency Act, but I don't expect any action on that anytime soon. But what we are seeing are market solutions kind of coming to the fore in the US, and I'll talk more about that kind of at the end. But right now, there are 20 cases that are pending in US courts. Primarily, I think it's really 4 courts they're getting filed in. And again, the Southern District of New York is a prominent one as well. Northern District of California, Delaware are others. And really, these are coming from different sectors. So there's a Thomson Reuters versus Ross is a case that you might be aware of and should be on your radar because it involves legal issues with legal research. So Thomson Reuters is alleging that some of its legal research behind a paywall with Westlaw was used as training data. And there, I think our trial is expected to begin this August. So we'll see some action there. Tremblay and Authors Guild are both involve authors bringing lawsuits against OpenAI for use of their novels, their literary works as training data. Anderson is about visual artists, and that's pending a motion to dismiss right now. Getty Images is interesting because it involves, they're alleging 12 million images owned by Getty are being used in training data, which raises the question of damages and how we assess damages in this kind of situation. We do have statutory damages under the Copyright Act, and the plaintiff is doing depositions right now in the Getty case. Someone mentioned in the last panel, New York Times versus Microsoft, and for that, I think there's some arguments that have happened in the last few weeks over Exhibit J. Exhibit J is the exhibit that's where the New York Times outlines the particular prompts they use to elicit the alleged infringement. And then just this week, I believe, OpenAI hired a team of litigators for 7 cases that they have going right now, which would indicate, I think, that they're gearing up for a fight. Or at least some posturing. So the big question is going to be whether there's fair use, right? And in the US, as mentioned previously, fair use is pretty strong. It involves the purpose and character of the use. Is it commercial, non-commercial? Is it transformative in some way? How much are you using of the work and how important is what you took, the quality and quantity, the effect on the market. And I would say, you know, consistently in cases, numbers 1 and 4 tend to be the most important. And you'll see arguments on both sides. Everyone wants to analogize to the Google Books case, when Google decided all of a sudden to go ahead and scan the world's books and make them available online. And commentators are saying two things. One, yes, this is just another Google Books case. And it's used transformative, and it's not used in a way that's going to compete with any of these authors. And equal arguments on the other side saying, this is no Google Books. It's different because the output itself in Google Books didn't create a direct substitute for the copyrighted work. And here there is a market, and AI is using it potentially to compete with these expressive works.
And what do you think about it? I mean, what is, like, again, your prediction, or on which side are you?
Okay, I have some predictions and suggestions. So, and I'm not going to take these exactly in order as they are here, but one, I think we're going to continue to see something you should have on your radar is that we're going to see legislation in various countries that are going to provide legislative exceptions for training data. And so if you have clients that are in the creative content industry, that's something really to think about because that could make an enormous difference in your clients' rights. I also think there's going to be an increasing focus on rights of publicity and authenticity. In the US, we don't have a federal right of publicity law. It's state-based, which I've always found a little bit nonsensical. But I think there's going to be a movement in that direction. And authenticity itself is, as a brand value, as a commercialization strategy, kind of the OG, that I think is going to become more and more important as we look from AI tools, as we're talking about here, to deep fakes and those kinds of issues. Importantly, I think market forces are going to end up working a lot of this out. We have talked throughout, you know, the last few hours, and we're going to talk throughout the next couple of days about how technology moves so much faster than law. And while we have motions pending and depositions are happening and the impotence of the US Congress and the EU is regulating in that space, I think we're going to see a lot of this market solutions coming forward. Companies working on licensing. Could there be pools of licensing, like we see patent pools these days? I think all of that is an emerging area for opportunity. And then finally, I just will say that I'm often telling academics they're kind of, you know, that they think about policy too much and not practice. But I think academics can say now that policy is no longer just academic only, that policy matters so much here. And just like Steve Jobs said, you know, we're poking at life. And what kind of life do we want? The ethics, the safety, all of this is going to come into play. And how do we want to construct this new world? We need to think about that. Will the frameworks that we generate incentivize creation of artistic works by humans? If AI can create perfect music that we love, do we care about that if it doesn't incentivize the creation by humans? Is there something special about humanity as authorship and as creators that we value uniquely? And how should we handle that? And I think how we answer, in conclusion, how we answer those questions should not and cannot get lost as we navigate this new terrain. And as Steve Jobs said, as we embrace it and change it and improve it, and as we all collectively make our mark upon it. Thank you.
Thank you very much, Meg. I would like now to land all these things that we have seen all over the world. I mean, I think that the US, it's always leading on these kind of subject matters. They have always been a reference, not only for the LATAM region, but for the world, because the authorities start seeing at things that then we start seeing in other countries. So I think that that's why this point of view is so important, but also to know what's going on in the region and how the LATAM region is facing these kind of things and what we want and how we want to use them for development and business growth and economy growth at the end. So I think, Juan Manuel, you can talk a bit about it.
I hope so. Thank you. Thank you for having me here. It's really a pleasure and an honor. I'm going to try to actually bring a little bit of what Megan just wonderfully exposed right now about, because as you were saying, it is a mirror in which we look. Even though our laws are somewhat different and somewhat different in origin, for the industry and for the entertainment industry and the media, the US is a reference. It's clearly where we're looking at. It's clearly where we're looking at all these cases and we're looking at all of this. And the last couple of years have been very exciting at Caracol because we've developed a team, a media lab that is dedicated to innovating and to creating new ways of exploiting entertainment and new ways of exploiting audiovisuals. And obviously, they have started to dip their toes in AI for the last couple of years. So we have had to ask this question that we are asking today. The first question is, well, as intellectual property lawyers, we're very protective, we're very maternal in the sense of, can this be protected? We have asked that question several times, and that's the first question that we were asked. If we create this through an AI tool, can this be protected? We've had a wonderful background that helps me a lot regarding that question. And so far, what we have found is that our answer to our team as attorneys, as in-house attorneys, was not really and not currently, not right now. For the same reasons that Megan mentioned, and because our laws in Colombia and in most of our countries are based inherently around the human being and inherently around the human input. So what we first did was look at our context, and thankfully we've had a chance to see a couple of cases in Colombia in which people have tried to register works of either visual works or literary works in our registration office. And we have found that they have met with rejection as well. There is still a very hard line of this has to be inherently human, this has to be created, and I think it makes sense because of how our laws are designed. It makes sense because, I mean, it is true that it is inherently human, and it is true that our laws are focused into protecting that spiritual input and that the spiritual relation that we wouldn't have moral rights if it weren't so. We wouldn't have that very controversial concept of moral rights when we're negotiating with parties in the US. Can you waive this? We cannot, because it is inherently human. And the other thing is something as human as death is the measure of the term of protection. So it is very hard to, right now, with the legal framework that we have, to conclude that there is a way. This can change, but I think it would require a fundamental change in the way we understand what an author is, the definition of an author. Currently, even though the word human is not specifically mentioned in our law, the other elements lead you to conclude that this is still inherently human, and this is what we try to transmit to our team, to our innovative team, that if you are going to create, you're going to have to know that it is unlikely that we will get the same protection, at least. There's a possibility of other types of protection, but these two cases, and I'm going to just briefly mention them. One of them is a visual work of Marimonda, which is a very colorful character from our Carnaval de Barranquilla. And it was denied. It was done through Midjourney with prompts very similar to what you described, Megan, very detailed prompts on what it should look like, and it was denied on a basis of not having that human input and not that human creativity there. And the other one is a very interesting work. It's a literary work. This guy sat down and had poetic conversations with ChatGPT. And that is the name of the work, actually. Like, it's poetic conversations with ChatGPT. Both of them were actually very transparent in saying this was created through an AI when they tried for registration. And those poetic conversations were also denied any protection because he was prompting ChatGPT to talk in a poetic way and at the end tried to register as a literary work and was denied registration. So we tried to tell them what you should do is have a very clear concept right now that you have to ask yourselves the question. We tell our creative team, is fully creating a work what we are striving for? Is that really what the industry wants right now? Is that really how we should approach this? Because you tend to think for the entertainment industry that the only function of AI is let's have an AI write a screenplay. Let's have an AI movie. Just put in a couple of prompts, a couple of thousand, 100,000 prompts, and make out a movie completely done by AI. And I don't think that's the objective right now for the industry. And again, looking at the mirror of the industry, that's not what we found. I'm going to talk about, a little bit about that later. That's not probably where we should be pointing at right now. And one of the first conclusions that we had is, I think if we focus too much on can I allow or can I have an AI create a fully fledged work, what we want to do, that will distract us from the actual potential, very interesting uses of AI in the entertainment industry and in the audiovisual industry. As far as legal framework goes, Colombia is trying to legislate around this already. Fortunately, in my opinion, they're not trying to just set out a list of prohibitions, like you cannot do this, you cannot. They're trying to define terms a little bit in the line of what the European Union is doing. Like, we're going to define some terms, we're going to define some principles and some ethical principles of how this should be developed, but mostly on how the tools can be developed. It's more focused at the purpose of having ethical standards and legal standards for how tools are created and for how tools are trained. So I think that is very interesting, and I celebrate that, because usually what we find in the legislation is that what they try to do is attack a very specific point. So they say, authors are worried that they're going to be replaced. So we're just going to throw in a prohibition of not replacing, just like that, just written so very specifically tailored to that problem, which doesn't really allow you a big possibility of allowing the market to regulate this and allowing the agreement between parties to how you use it. So it's a positive perspective, I think. It's how you should approach this. This should be standards. But I also agree with a crucial point Megan mentioned, that is, I think that what we have now, and that is our other big conclusion through these two questions, the framework that we have right now is sufficient. There is this notion that this is like the Old West, that there is no law, this is no man's land, and because the technology is able to do it, we should be able to do it. And I don't think that's accurate. I think that we do have a very strong framework, both in intellectual property rights and in what we call image rights, which are the equivalent of publicity rights, or more or less the equivalent. I think we have enough of a groundwork there to know what we can do. And we developed something back home that we playfully call the Jurassic Park principle, which is just because the tool can do something doesn't mean we should. And that's been well received by our creative team, and it has helped them focus, and they have brought us in the conversation from the very beginning, from the inception. We're not just sitting there at the office waiting for we did a movie with AI, and the script was written through ChatGPT. We're going to launch in 3 days. What are we going to do? No, we're there from the inception. We're there helping them out, and we have helped, I strongly believe that we have helped them navigate these waters in a sense that we are really finding interesting ways to bring AI into the industry and do innovative and very cool things that I hope you find as cool as I do with this. And obviously, this is what we're doing by looking at the industry and looking at our mirror in the US and Hollywood and the TV industry in Hollywood. We found that when you stop looking at it as an issue of, can we do a full song with an AI? Can we do a movie? Can we do a screenplay with AI? You kind of put that aside and you find very specific uses that are being done right now and that do not have this complicated issue of whether it should be done and doesn't have this complicated resistance against replacing, because there is a big resistance. One of them is I think it's fascinating. It's they're doing digital twins to facilitate location scouting, which anyone in the industry will tell you, location scouting is an absolute nightmare. It's expensive, it's complicated, it requires you to travel if it's a big production, if you need to go to the desert and find a production location, it's going to be expensive, it's going to be complicated, it's going to be an actual nightmare. And this location scouting is done through AI that replicates the locations, replicates the place, and it allows you to travel it at home, at the office, or on your computer, and have a notion of what the location looks like. So, and this is the journey through the twin, to the digital twin, is done by a human, but the creation of the actual twin is done through AI and through data, through AI. So I think that's a wonderful use that it's been overlooked. It's been, and it has an applicability that it's really boundless. There's a couple of examples here too as well of digitally altering the resemblance of the characters and of the actors. The two examples I'm bringing here are one, I think I bring him here because I think it proves the point that the framework is enough. One of them is Harrison Ford was made to look the age he was in, I don't know, 1983 for a good 30 minutes of a movie. And it was done with AI tools that allowed you to bring images of Harrison Ford in his youth and his performance in his 80s right now and create a younger version of himself. And the other one is the example of late Peter Cushing, who was recreated. He died in 1994, and he was recreated for a Star Wars movie, and it was digitally recreated using AI tools. And the resemblance is uncanny. The resemblance is really, I mean, you notice it still, but we're going to get to a point where we won't. And I think it proves the point that the framework is sufficient because both cases were clearly done with the authorization of the actor or of his family, of the titular right holders of his image. And I don't think anyone here or anyone in the industry would really have a notion that someone can do this without that. And that is because we have a framework that says to use the image of a person, to recreate a person in this way and have it actually perform digitally. You need that. You need the authorization. So I think it gives us a clear image of that's what we need to be doing. We need to be looking for authorizations, and we need, just because the tool can do it doesn't mean we should go and take the image and use it in that way. I'm going to skip the other examples to go into where are we going, where is this taking us, and now what we are doing back home at Caracol with artificial intelligence. We are developing a few different possibilities. This is Symphony. She is one of the first developments that we did with an AI. She was done through Midjourney, with a full license from Midjourney and with full, We obtained a license that allowed us to create this character with inputs that were originally all ours. So it was fully clear. We did this with a full clearance of what we were using. And she is a fourth judge in a reality show, in a musical reality show. She has this, well, I don't know if it sound, no, I promise you she's talking. But she does not. I don't know if any other AIs do, but, but definitely that is exactly what we did. We made sure that the voice, which is AI generated, came from a fully authorized input and a fully cleared input, because we did not. And now that you mention it, she maybe looks a little bit like her.
She's completely Scarlett Johansson.
Yeah, okay. So hopefully she won't consider it the same use that she's considering the use of her voice, but if she does, well, I'll let you know. Does anyone know a good lawyer?
Could you please raise your hand if you think this is Scarlett Johansson? Okay, not that much.
That's not too bad. That's not too bad.
Just a few of you.
Yeah. This was a first attempt. It's been fairly successful. We are also developing now a chatbot that TV viewers and fans of the show can interact with her and ask her questions about the show, about the contestants, and we're trying to implement tools that will allow her to judge the contestants in a very objective way, you know, like measuring pitch and measuring performance. But it's mostly, right now, it's just interactive. Mostly just she interacts and she has like this playful banter with the human judges, and it's proven successful, and it gave us way for this, which is actually a set of digital influencers created by AI. They are designed to cater to specific advertisement needs. They look a little bit more real than our first attempt does now. And again, we obtained full clearance for the inputs that created them, full clearance for the license. We know where the inputs come from, and we are making sure that they are not, and that their interactions are also ethical and correct, and that they're not biased and they're not having these inputs. So it's still very human curated. It's still very human accompanied. They're already online and they're already working. They have their social media accounts. And the idea with this is to have a digital influencer that can talk to our followers and our viewers about different aspects. So there's a sports guy that will talk about sports. There is fashion. There is a more journalistic approach to everything. The idea, of course, that we have is that this is not going to be the norm. This is just like something we want to try out as a novelty and as a way of bringing new audiences and new forms of interaction. But this is not going to be, the plan is not to be this to become the only journalism we do, because again, we have a firm belief that this is also inherently human, and this is also, but we want to try this because we think it should be something that we learn from in order to do more advanced things later and to have more uses for artificial intelligence.
A quick question?
Absolutely.
Sorry. I just want to ask you a quick question. Do you disclose, like when you're using the influencers, do you disclose it's AI or?
Yes.
Oh, that's great.
Yes, definitely. That is part of the discussion we had with the creative team when they came with this. The first question was how would we protect them?
Yeah.
And we had a whole discussion about the possibility of trademark protection, the possibility of going that way. But also we gave them some guidelines on what to do to be fully transparent that this is an AI-generated character that this is not meant to, that we're not trying to fool the consumer that this is not. Because some of them are very lifelike already, and and the movements, you can see them in the videos, are very, very lifelike. But we are disclosing that, and we are just being fully transparent, which I think is the way to go. I think regulation, going back to what is happening with regulation, should definitely ask of AI developers and users to be fully transparent in that sense. We're also experimenting with dubbing through AI, which I think this is me personally, I think dubbing should be used on certain types of contents only, because I think dubbing is in itself an art form. Like, the people who dub a movie in a different language have to act out the movie again. It's an interpretation in my way of viewing. But that's not necessarily the case for a reality show where people are just talking and being real. And don't tell the people back home that I quoted that they don't have that performance element that I think an AI dubbing can be fully useful for sales of a reality show outside of Colombia and outside of Latin America. And another use, and I'm just going to just briefly breeze through this, is we are using an AI system to personalize your website experience without cookies and without data, without taking any data. It's not going to use the same personalization for your next visit, but if you stay on the website and you navigate the website without taking any data and without using any cookies, it will customize the website, and it will give you a customized experience in the website, learning from your clicks and learning. And the idea of this is actually to keep people engaged in the website. People find that the website responds to their taste and responds to their consumption and starts giving you, and eventually that can give you also specific advertising, which is very interesting for our advertisers.
Yeah, to get a better experience, like to
exactly
boost that experience.
Exactly. That's the idea, and I think we like the idea that we're not taking data from the user. We're not necessarily taking data. So part of our job here has been to obviously incorporate all of this in our agreements. We're looking for an approach that will allow us to talk to other parties in how we deal with this. Currently, we have like I said, our focus is not to use AI to actually develop a fully fledged work right now. That is, it's a policy that we decided to go with, and our team is fully aware of it and is fully on board with it. So what we're doing, and it has been very well received by writers, is that we looked at what happened with the strikes in the US. We looked at the results of that strike and the resistance that that strike showed regarding the notion that this is going to be replaced, the notion that this is going to be, we're going to just dismiss all writers and we're going to have ChatGPT write all the screenplays and tell them to write them like he does. You know, because that's not where we're going, and we're actually telling writers in the agreements very openly and very transparently that we're doing it as a prohibition in a sense, or we're doing it as a representation that they're not going to use AI tools for writing unless it's fully disclosed and unless it's fully approved by the network. They have fully embraced this because they do not like the idea, and the writers that we work for and the professional writers, I think you're going to find in the industry that they are not interested in using the tools to actually write their screenplays. They don't want that, and I fully understand why. I fully understand what they are going for. And we as attorneys, we have the same reaction. Like we said, okay, this is going to help us. This is going to be very helpful for us, but it will never be able to analyze an agreement or take a decision the way humans do.
To substitute us to take our,
Exactly.
our part,
Take your jobs.
our jobs.
So we found that it's a very interesting approach, and I think if the other players in the industry had these discussions among themselves as well, the way we are doing it right now, it would greatly benefit the discussion and the conversation with them, because it would help us actually talk about what are we going to do with AI and what is off the table and what is on the table. Our approach has been to be very clear and very transparent in our agreements, and so far it's worked very well. And the other thing we're doing inside for the company is we're developing manuals and guidelines in the use of AI. We help them, and we took a lot from the discussions happening in Europe and the US and everywhere really about what is ethical use of AI. And we have right now, it's an official manual for the development team and for any area in the company that has these guidelines. They're really not coded or anything like that, but it's really a set and an explanation of the ethical way to do this and why we need to use tools that give us the guarantee that we are doing this without infringing other people's rights and without putting our own rights and our own property at risk. Because it's really commonplace now to say this, but for a production company and a television network, this is our biggest asset. Intellectual property is our biggest asset. So what we have been trying to do is focused on that. And surprisingly, because as in-house lawyers, we are usually the big bad, and they're always saying no, and they're always avoiding us from creating. We have found that this synergy with them and being part of the creative process, and I think this goes for in-house attorneys and outside counsel, being there from the inception of this project has proven to be incredibly helpful and has proven to give us an understanding of what the innovators want to do and give them the understanding of the Jurassic Park principle mostly, which is, again, just because the tool can do it doesn't mean that's what we should be striving for. It doesn't mean that's what we should be trying to do. It's been an experience. It's been, like I said, an amazing journey. And I think, to conclude, we really have two paths when approaching this. One is the path of saying, this is no man's land, and I'm not going in there because it's dark and we have no idea what to do and we have no idea what to expect. And just stay put and see what they're going to do and see if the legislation prohibits it or allows it, and then go. And there's a different path of what we're doing here, which is having a discussion, knowing and trusting the framework. I think it's essential that we realize that we as attorneys have the tools and have the road, probably not paved, but at least sufficiently clear that we know what to do and we know what the limits are. We know that we are not supposed to take somebody's voice without their permission, and I'm not saying that they did, but if they did, I don't think any of us here would say, yeah, I think they're allowed to do that. We know that there are rights. We know that there are things that we can and we cannot do. So I think that should give us the elements to choose a path that says, I'm going to embrace this, and to use the wonderful term that was coined for the whole event, to coexist. I think we are able to coexist. I think we are able to bring this into an inherently human and an inherently creative industry like the audiovisual industry, which is where I'm talking from. But I think we can bring it, and I think we as attorneys are essential for that process. I think we as attorneys, and whether we are outside counsel or in-house or academics, we have the tools to tell these creative teams that are developing these very interesting and these fascinating tools to bring them into our industry and to use them into our industry without stepping on the toes of what the creators, which are essential to this industry, feel that this threat threatens them. And I think we are also the tool to bring them into that coexistence. I think we are the element that can explain to them how they can bring and listen to them and listen to what happened with the strikes and listen to what happens with all these grievances that says we're going to be replaced, we're going to lose our jobs. So we're not. We have to use this as a tool to potentiate our jobs and to make them, to make us much more creative. Thank you.
Well, there's like just 1 minute left, and I think that we are all hungry, but we still have a chance. If any of you have a question or want to add a comment or something, I think now it's the moment. Otherwise, we can go to lunch.
Thank you. Thank you both for great presentations. I wonder, is the land of predictions, how you see will be the evolution of the originality concept with all this development?
You know, that's a great question, and I think that the originality concept has been problematic in U.S. copyright law for a long time, and in some ways we have, you know, perhaps it hasn't been high enough, and so I think when it comes to originality, what that means in U.S. copyright law is really just a creative spark. It doesn't have to be novel. It doesn't, you know, if you wrote Harry Potter and I also wrote Harry Potter and it was complete independent creation and just a coincidence, you know, we would both have copyright protection over that work. And so I think that, you know, where I see the interesting component is sort of drawing on some of the photography cases, some of the other tools cases, so the photography cases, the film cases, and saying, where is that creative spark? And is that happening kind of, you know, what combination of human plus tool? Is it 75% human creative spark and 25% facilitated through technology? But I think that's really where those questions are going to lie. And I really wish that we would stop using the term originality. I mean, it's foundational, so it won't happen, but it's such a misnomer because that's not really how it plays out in case law. Great question, Martín. It's like a big burden between, if you ask a question now, it's like from between now and lunch.
Any other question or comment? No? Well, I think that we are free to go. Thank you very much.